Hello, bachcho. Let's see passage 1. Passage 1 talks about the Muslim law or Islamic law. It is also known as to originate from the divine and not like the man-made laws that are passed by the lawmakers and are governed by the principles of modern system of law. Islam signifies submission to the will of the Lord and means peace, purity, and and salvation and obedience. Muslims believe that there is only one God, Allah, and the traditional Islamic law or Islam's legal system is well known as Sharia. It is an Arabic word which in literal sense is referred to as the way. Sharia is originated from Allah, and that is the reason that Muslims consider it as holy. Muslims consider it a word of God that regulates and evaluates human conduct. The Sharia is also derived from Prophet Muhammad's principle and by Muslims legal scholars who interpreted his teachings. It is said that Islamic jurisprudence is also something that goes to the lifetime of Muhammadin. For Muslims, the Quran is the only disclosed book of Allah. In case of the Rangtakat and versus Prakal, ILR 45 Madras 1986, it was stated that there was basically two beliefs of Muslims. First is the existence and oneness of God, and second is the belief in the truth of Prophet Muhammad's mission. The Quran is derived from the Arabic word Qurra, which means to read. So basically, Quran means to read. Every word of the Quran is the word of God and communicated to the Prophet Muhammad through the angel Gabriel for the benefit of mankind at different times, places, situation during the period from 609 to 632 AD. The Quran is stretched in Arabic and it consists of 114 chapters which are known as surahs. Surahs thereafter contain 6666 verses which are called ayats and a total number of 77 and 934 words. Out of this verse, 200 dealt with legal principles such as marriage, maintenance, transfer of property, inheritance, etc. The Quran was disclosed over two periods which are sources of Muslim law. The primary sources are the Quran, the Sunnah, the way of the Prophet, the Ijma, the consensus of the Islamic scholars, and the Qiyas, that is the reasoning by analogy. Another secondary source are judicial decisions, custom, and legislation. Primary sources are Meccan and Median. The words of the Quran are divine. They cannot be amended, revised, or modified by any institution of human agency. The sacred book has been translated into several languages as well. Sunnah is also known as Hadith or Sunnah. It is the tradition of Prophet Muhammad. The term Sunnat means a procedure, the trodden path, or by way of action. Quran consists of words of Allah, but on the other hand, Sunnat indicates some precedents, acts, languages, and the practices by Prophet. Whatever the actions of the Prophet were, or the Prophet said or did, was considered as tradition. According to Islamic law, there are two types of revelations, that is manifest, zahir, and internal, that is batin. The traditions of Sunnah comprise of Sunnat ul Fail, Sunnat ul Tukrir, and Sunnat ul Qawl. Now let's see the questions. Question number 1 says, in case where a Muslim individual claims self-defense based on the principle of Islamic law, which principle source would they likely to refer for guidance on moral conduct and legal principles? A says the Ijma, consensus of Islamic scholars. This is a wrong option because it is a secondary source and not the primary source of guidance. B says Sunnat. Again, this is a secondary source and not the primary source, and again a wrong option. C says Quran. That is the right option because it is the utmost primary source to derive the principles of Islamic law. D says the Qiyas, reasoning by analogy. Again, this is a secondary source. Let's see question number 2. It says, considering the legal framework described in the passage, if a Muslim scholar aims to derive legal rulings by drawing analogies from existing precedents, which secondary source of Muslim law would they employ? A says judicial decisions. This is a wrong option because they are Not prima facie a source. B says legislation, again a wrong option. Option C says customs, again a wrong option. D says sunnah, the way of prophet. This is a right option because it is a it is a framework that describes the acts, precedents, and decisions that were followed by the prophet and can be referred to derive the legal framework. Third question says, in a hypothetical scenario where a dispute arises regarding the interpretation of a particular verse from the Quran concerning property inheritance, which primary source of Muslim law would hold the highest authority for resolving the issue? A says the Sunnah, the way of the Prophet. This is considered as a wrong option because it is considered as a secondary source when we compare it to Quran, that is the primary source and holds highest authority for resolving the issue. B says the Qiyas, again a wrong option. It is also considered as a secondary source. C says Quran, that is the right option. D says the Ijma, that is again a wrong option. Let's see question number 4. It says, if a Muslim community is faced with a new social issue not explicitly addressed in the Quran or the Sunnah, which methods of legal reasoning described in the passage would likely to employ to arrive at the decision consistent with Islamic principles? A says customary law, though it can be referred to when we see a issue, but if it is a new social issue, customary law cannot be per se relied upon. B says judicial decision. This is again a wrong option because when we see, it is considered as a secondary source when we compare it to Qiyas, that is considerably the primary source. C says legislation, that is also wrong option. D says Qiyas, that is the right option because when Qiyas is the reasoning by analogy, and when a new social issue is faced, experts and jurists and researchers of the Muslim law rely upon Qiyas to describe and arrive at a decision consistent with Islamic law. Question number 5 says, in a scenario where a Muslim jurisdiction is considering implementing new regulation on marriage practices, which primary source of Muslim law would carry the most weight in guiding the decision making process? A says the Sunnah, the way of the Prophet. This is a wrong option because when we consider it against Quran, it is a secondary source. B says Ijma, the consensus of Islamic law scholars. This is again a wrong option. C says Quran, that is the right option because it is the way of the God and it holds the utmost importance, or acts as a primary source for Muslim law for carrying all the scenarios including marriage practices. So this is the right option. D says the chaos, that is again a wrong option. I hope the passage was understandable. All the very best.